Let's shift gears. Our last topic this morning is litigation. And for that, we'll turn to Kate Campbell. Kate, while the Biden administration is signaling increased enforcement, and we've talked about that, what can our clients expect to see on the litigation front over the next few years?
Thanks, Carol, and good morning, everybody. So I think that question, Carol, requires a fair amount of crystal balling, but I think what I can say with some certainty is that environmental litigation against private industry is likely to be very active and will likely see an uptick as compared to the past 4 years, with both the United States as well as environmental nonprofit groups serving as plaintiffs. So unlike the Trump administration, which as we've discussed today was really focused on sort of returning to basic environmental compliance initiatives, making things easier and more streamlined for the regulated community, the Biden administration is clearly focused on a new set of complex and enormous priorities like climate change and environmental justice. And from a litigation perspective, I think these areas of focus are likely to have an effect not only on what cases are brought and when, but also when they're settled and how they're settled. So we've talked already a lot about SEPs this morning, and unlike the Trump administration where cases were settled by way of civil penalties by and large, settlements in the future may look different with SEPs and third-party payments involved, and likely larger or more diverse stakeholders engaged in the process. More generally, it's important to keep in mind that both the administration and the regulated community is dealing with a vastly different judicial landscape than when President Trump took office 4 years ago. You're all, I'm sure, well aware that President Trump nominated 3 new Supreme Court justices to the High Court, but he also appointed over 200 new federal judges in the past 4 years, including more than 50 on the courts of appeals. As a general matter, these judges are going to likely be on the lookout for executive branch overreach, and they're also likely to be more reluctant to defer to agency interpretations under the Chevron doctrine and similar doctrines. Finally, one quick word about rulemaking and permitting decisions. I think we're going to see the new administration pay more and more attention to the Administrative Procedures Act and the intricacies there. The key for the new administration is going to be to ensure that they're establishing the right record to justify their actions in anticipation of what is almost certainly to be very contentious and active litigation as they attempt to develop their environmental policy agenda moving forward. The Trump administration did not seem too concerned with this over the past 4 years, and it came back to bite them in the courts. And I'm sure the Biden administration is well attuned to that.
Okay, so you mentioned environmental nonprofits acting as plaintiffs, and I assume by that you mean citizen suits. Before you talk about what we might see on that front over the next 4 years, can you just briefly touch on the role that citizen suits played during the Trump administration?
Sure. So probably comes as no surprise to most of you listening in this morning that citizen suits were alive and well over the past 4 years. In fact, from the very beginning of the Trump administration, between the regulatory, rollback efforts, more relaxed enforcement, and even reductions in EPA budgets and staffing, those were all met with a pretty notable surge in donations to environmental groups across the country. And that new money was put to work very quickly and in a very real and direct way. So almost all of the major federal environmental statutes, including the Clean Air Act, the Clean Water Act, RCRA, they include citizen suit provisions that by statute allow individuals and groups who are harmed by an environmental violation to step in the shoes of the regulator, to step in the shoes of EPA, where the agency isn't acting, and to sue the companies directly to address violations and seek civil penalties. Now, there's a couple reasons why we saw a surge in citizen suits over the past 4 years. I'll touch on them very briefly because I think they'll signal where we're going to go in the next 4 years. First, citizen suit enforcement naturally increases during periods of relatively less stringent regulation. That's sort of an obvious one. Second, fundraising was huge. And by the way, this is likely not to go away anytime soon. In fact, I read some statistics that barely a month into the Trump administration in 2017, many environmental nonprofits reported smashing all of their prior fundraising records. Third, and this is a point, Carol, that you raised during your discussion on enforcement, access to monitoring data has never been easier for environmental nonprofit groups. Permit compliance and monitoring data is readily accessible online through EPA and state databases. And as we continue to transition to mandatory e-reporting, it's making it increasingly easier for environmental groups to identify actual or potential violations at a facility. And again, this is only going to become sort of more open and accessible to the public moving forward. Finally, and perhaps the most significant incentive for environmental groups to use citizen suits as a tool to promote their own agendas is the prospect of attorney's fees. So in addition to civil penalties, which by law have to go to the US Treasury, a successful citizen suit plaintiff can recover its fees and costs by statute. And the courts generally apply a fairly low standard of recovery, provided that there's some indication that you've prevailed in some fashion. So from an environmental nonprofit group's perspective, if there's some real merit to a claim that yes, there's a violation at a facility, the citizen suit vehicle is a pretty low risk proposition for the group to not only seek relief in the form of penalties and injunctive relief, but also to ensure that it's covering its attorney's fees and costs.
So Kate, apart from the increase in volume, was there anything different or new about the types of citizen suits that we saw over the past few years?
Yeah, this is a good question, Carol. So apart from the numbers, we definitely I saw a pretty notable expansion of the types of legal theories and harms that environmental NGOs have used the citizen suit vehicle to try to address. And it's kind of interesting because these provisions in these statutes are pretty old. I mean, the citizen suit provision in the Clean Air Act was enacted in 1970. And notwithstanding that, we're definitely seeing change afoot with creative theories being asserted and the waters being tested in the courts. What I think is particularly significant about this as we enter the Biden administration is that in many instances, the types of these theories that are being tested overlap in pretty significant ways with some of the key priorities of the new administration. And I'll offer two quick examples for you. So one is a case pending in district court in Alabama. It was filed in 2016, so before Trump took office. It was brought by the Tennessee Riverkeeper against 3M. The suit remains pending, and it's a RCRA citizen suit that's alleging that ongoing releases of PFAS, so we just spoke about that for quite a while with Rob, that PFAS releases have contaminated the Tennessee River and surrounding groundwater, and that they caused an imminent and substantial endangerment under RCRA. 3M sought to dismiss that claim in 2017, and they were unsuccessful. And part of the court's rationale for allowing the citizen suit to proceed was the fact that PFAS compounds are emerging contaminants and they're not yet regulated by EPA. So again, you see a situation where citizen suits and environmental nonprofits are sort of pushing issues that are awaiting regulatory reform. The second case is, I find super interesting. It's a climate change case, and it's one of several that we're seeing being filed in the federal courts with differing results right now. So the one I want to mention briefly is pending in district court in Rhode Island. It's a lawsuit filed by the Conservation Law Foundation against Shell. And CLF asserted claims under both RCRA citizen suit provision as well as the Clean Water Act citizen suit provision. And the basic allegations in the case are that Shell has failed to adequately prepare one of its terminals for the impacts of anticipated future climate change. So it's an adaptation claim, failure to adapt to anticipated changes in climate. This past fall, the district court denied Shell's motion to dismiss, finding that Conservation Law Foundation had standing and that there were sufficient allegations to show a substantial and imminent endangerment under RCRA, as well as under the Clean Water Act. The Clean Water Act theory, I think, is particularly interesting. The allegation relates to the terminal's NPDES permit, and there's language in the permit that requires the facility to employ, quote, good engineering practices. It's a pretty generic term. But CLF is saying that what that means is that Shell needs to prepare the terminal for catastrophic weather events, and that it is not employing good engineering practices by sort of not taking the actions that CLF thinks are appropriate and needed.
Really interesting. So what about the future? We expect to see an uptick in enforcement at the federal level. Can we then expect to see fewer citizen suits?
So that's, I think, a common sort of reaction. I disagree with it. It is true that fewer citizen suits tend to be filed when the sitting administration is prioritizing enforcement and compliance. But with that said, I don't think citizen suits are going to go away anytime soon, and I'll give you a couple of reasons why. So first is, I think it's important to keep in mind that over the past 4 years, the NGO community was focusing significant resources in fighting the Trump administration's rollbacks and their deregulatory reform agenda. Now that we see the Biden administration stepping in with the expectation that they will roll back the rollback, so to speak, it's likely to mean more resources are going to be shifted to citizen suit enforcement. Second, even if environmental NGOs believe that the Biden administration will pursue enforcement initiatives and their policy agenda more aggressively, it's still likely that they're going to consider those initiatives insufficient. Third, I think we're going to see some citizen suits being brought with more frequency as a way to promote the new administration's environmental policy agenda and force action more quickly than could be achieved through statutory or in particular regulatory reform, which, as you discussed earlier, Carol, it just takes time. So again, I come back to SEPs and other discretionary tools. Now that we have these additional tools in the settlement toolbox, I think we're going to see citizen suit settlements driving policy and progress around things like climate change and environmental justice. And then one final point, and it's just a practical one. Citizen suit litigation is a way for environmental groups to justify their donations and to ensure that money continues to flow in. So by showing that increased donations are being put to work in a very concrete and visible way through active litigation, it helps keep the lights on, and that's just plain and simple.
Okay, Kate, last question for you. Do you have any key tips or takeaways for our audience this morning?
Sure. So I have lots of thoughts on developing litigation defense strategy, and I'm happy to talk to anyone offline about that. But let me just focus on a couple sort of big issues to think about moving forward. First is don't underestimate the environmental NGO community. They are sophisticated and well-funded. I've seen firsthand over the past couple of years their use of social media. They use it in very effective ways to shape their narrative, and they've probably never before been better supported and better mobilized. Second, it's important to recognize that many NGOs, including regional and local ones even, have their own idiosyncratic ends that may not harmonize well with the concerns of your local community or the expertise and experience of the federal agencies, EPA, or even the state agency. And so, Carol, you were referencing, as one of your tips, make good neighbors. And the same goes in terms of anticipating and trying to blunt future litigation. Take the time to develop your relationships with your regulators and your local community so that you have that support system in place to the extent you can. Third, have a plan in place in the event of litigation. So I tell my clients this all the time, but you need to ensure that you have a plan in place to implement a timely and comprehensive litigation hold. For a citizen suit, one can't be brought until a 60 or 90-day notice is provided. So as soon as that notice letter comes in, you need to make sure that you're going to implement your hold. And then I have a last piece of advice, and it's what to do if you receive a notice letter. Obviously, you're going to work with your lawyer to figure out the strengths of the claims and your possible defenses, but I would really encourage you, if you get one, to do two other things relatively quickly. First, figure out if you might be facing a TRO or a preliminary injunction proceeding. And if you think you might, prepare as far as you can in advance. These proceedings are intense, the stakes are high, and while often companies find themselves having to defend them on what is truly an emergency basis, after all, that's what these proceedings are for, the notice requirements that I was just referencing in the citizen suit can give you extra planning opportunities, and you shouldn't squander them. And the last one is the following. Evaluate the costs and benefits of early settlement, and consider going directly and proactively to your regulator as a pathway to pre-litigation resolution. Each of these citizen suit provisions have what is called the diligent prosecution bar. The basic concept is if EPA or a state is diligently enforcing against a violation, then a citizen suit asserting the same violation typically can't be brought. So with this in mind, depending on the circumstances, if you get a notice letter, it may actually make sense to invite EPA or your state regulator to take enforcement action against you so that you can blunt the citizen suit and prevent the attorney's fees claim before it's even filed.